5 seconds to go. Start. It also has a constitutional position after the amendment of the Constitution, but the words used in the Act are that the factory must be under the control of the government. Any further doubt in this regard, which we may entertain, is banished by the provisions of Section 90. Section 90 contemplates exemption of factories or establishments belonging to the local authority. Initially, the said provision contemplated power to exempt any factory or establishment belonging to the government or any local authority. After the omission of the words the government or by Act 29 of 1989 with effect from 20th October 1989, the said provision contemplates power with the appropriate government after consultation with the corporation ESIC corporation to exempt any factory or establishment belonging to any local authority from the provisions of the Act. It must be noticed that proviso to Section 14 was inserted by the very same amendment with effect from 20th October 1989. The results of this legislative exercise cannot be overlooked. The position therefore is that in respect of a factory which is belonging to a local authority, unless power of exemption is exercised by the government, it would be covered by provisions of Section 14 of the Act. In other words, it would be a factory like any other factory. It would have to be compliant with the provisions of the Act. This is for the reason that a factory or an establishment belonging to or under the control of the government alone are within the purview of the proviso, which in turn is subject to the imperative condition or rather the indispensable requirement that the employees are in receipt of the substantially similar or superior benefits than provided under the Act. We feel that the facts of the case at hand are almost identical, neither in the pleadings of the writ petition nor in the counter affidavit filed on behalf of the respondent Nagar Nigam in this court. Is there any indication that the respondent ever sought for or was granted exemption by the appropriate government by exercising powers under Section 90 of the Act of 1948? In the case of JP Lights India versus Regional Director ESI Corporation Bangalore, it has been laid down that the job of repairing the machinery is covered under the definition of manufacturing process. The appellant corporation had issued notices to respondent Nagar Nigam to show cause as to why the recovery of statutory contribution under Section 40 of the Act of 1948 should not be effected from it. However, admittedly, no response was given by the respondent Nagar Nigam to such notices. There is also no dispute that for the earlier periods between 1964 to 1978, the respondent Nagar Nigam made regular contributions under the Act of 1948, thereby conceding to the position that its workshop was covered under the definition of factory where manufacturing process was being carried on. If at all this situation had changed in the period subsequent to 1978 and before issuance of the notice under Section 45A of the Act of 1948, the respondent Nagar Nigam would be required to demonstrate the same by providing appropriate evidence to the authorized officer in response to the said notice and establish that it was not covered under the definition of factory. Stop.